Midwest Environmental Advocates is a nonprofit environmental law center that works for healthy air, water, and land. It's involved in a number of different things, including the fight against forever chemicals, PFAS, through litigation. They're also working on manure spreading rules and water issues. Staff attorney Rob Lee grew up in the Ozarks, enjoying the outdoors, which he still does. He received his law degree from the University of Notre Dame, where he served as president of the Environmental Law Society and received the award for outstanding achievement in energy and environmental law. Robert Lundberg works with Wisconsin tribes to protect clean water. He is a graduate of UW Law School and received a master's in environmental studies from UW's Nelson Institute for Environmental Studies. During law school, he was awarded the Mettner Foundation Scholarship for Public Service and served as vice president of the Indigenous Law Student Association. Please welcome Rob Lee and Robert Lundberg. Go ahead.
Thanks so much, Craig, and everyone for having us and for being here. First off, I'd just like to acknowledge that the state of Wisconsin encompasses territories of Dakota, Ho-Chunk, Menominee, Mohegan, Ojibwe, Oneida, Pequot, and Potawatomi nations. And most of these nations and their peoples remain present within what we now call Wisconsin. In Milwaukee, we are within traditional Potawatomi, Ho-Chunk, and Menominee homelands along the southwest shores of Michigamme, North America's largest system of freshwater lakes, where the Milwaukee, Menominee, and Kinnickinnic rivers meet. And while these acknowledgements are important, Midwest Environmental Advocates endeavors to support Native people and governments through the work we do and encourages everyone to do the same. So as Craig said, I am Rob Lundberg. I'm an attorney and Equal Justice Works Fellow with MEA, and I work primarily with tribal nations around the state on a range of issues, a lot around water, as well as various extractive industries like mining and pipelines. And I will hand it over to my colleague, Rob, to give us a little roadmap of our presentation today.
Good morning. First, just want to make sure everybody can see the title slide here in its kind of burnt orange color, and that is what we're looking at. Okay, and good. But as Rob Lundberg indicated, I am Rob Lee, a staff attorney at Midwest Environmental Advocates. Actually served as a legal fellow here before that, and as a law clerk before that, and so just really privileged to work for such a great organization and advance all the issues that we work on. I specifically work on some of the PFAS related issues I mentioned earlier, which we'll touch on briefly, I believe, at the end. And also, along with Rob Lundberg, work a great deal on our fight against new fossil fuel infrastructure here in Wisconsin, which we'll also be talking about. So just a brief roadmap of our discussion today. First, Rob Lundberg will open it up just with some background information about Line 5 specifically and some of the recent developments regarding its ongoing operation in northern Wisconsin and over in Michigan. And then I will overview our ongoing opposition to Line 5, and hopefully in doing so, we'll impart some information about the different regulatory processes involved. So just kind of do that in that context, though. I also thought it was relevant for this discussion here today to mention the felony trespass bill and why that's important, a bill that was passed a couple of years ago. Rob Lundberg will touch on missing and murdered Indigenous women issues around pipeline constructions, and finally talk about some jurisdictional issues between the federal, state, and tribal governments. And as I said, we'll try to, at the end, touch on, if we have time, on a recent action, well, not an action we filed, but a motion to intervene in an action regarding DNR's regulation of PFAS, and Rob Lundberg will finish by touching on some updates to the National Environmental Policy Act. And as indicated, we will finish with a question and answer. So we may move a little quickly through that stuff to make sure that we do have a robust question and answer at the end, and want to make sure we have that time. But anyway, with that, I'll turn it over to Rob Lundberg to get us started.
Thanks, Rob. If you could go to the next slide. So we're discussing the Line 5 pipeline today, but first I wanted to situate that just a little bit. So this is a continent-wide map of the Enbridge pipeline companies, different pipelines across Canada and the US. You can see it's quite a intricate network, generally carrying oil and natural gas products from Western Canada south and east through the US, either to Eastern Canada or to refineries in the US and eventually down to the Gulf for refining or transport. Slide. And zooming in on our region of this map, Line 5 starts up there sort of in the left center of the map at Superior. In Superior, Wisconsin, there is a terminal facility, and then it runs eastward across northern Wisconsin and the upper peninsula of Michigan, across the Straits of Mackinac, where it turns south, across lower Michigan, and then eventually turns back east and finishes back in Canada in Sarnia, Ontario. And I'll point out as well that that terminal where Line 5 starts in Superior is fed by several other pipelines in Enbridge's network, including Line 3, which some of you may be aware of, is currently being rebuilt and expanded in Minnesota amidst quite a bit of controversy and strong opposition from several of the tribal nations there, as well as environmental groups and many others in that state. There's also ongoing controversy where Line 5 crosses the Straits of Mackinac between the upper and lower peninsulas of Michigan. Many tribes within Michigan have treaty reserved rights to fish within that area of the Great Lakes, which they worry that any potential spills or other releases in that section of the pipeline could really significantly harm those treaty rights. And additionally, the state of Michigan last fall canceled the easement that allows the pipeline to sit on the lake bed there at the Straits. And actually, Enbridge, according to that cancellation of the easement, was supposed to cease operation of the pipeline last month, which they did not do. So that is progressing through litigation to see how that will be resolved between the state of Michigan and Enbridge. Slide. So just to back up a little, Line 5 was constructed originally in 1953, then called part of the Lakehead pipeline system. And much of the line still today is that original 1953 pipeline. And so the pipeline has actually already been in the ground and in operation much longer than its original anticipated life when it was constructed. Slide. And here, obviously a map of the northern half of Wisconsin. And the different colors here are different treaty territories, treaty cession territories from different treaties between the US government and various tribal nations signed in the 1800s. And these main two here, the yellow and gray, represent areas ceded by Ojibwe or Chippewa nations. And those are the areas where those tribes still retain rights to hunt, fish, and gather outside of their reservation. So across those entire 2 blocks of color, the yellow and the gray, and those extend as well into upper Michigan and a little bit into eastern Minnesota. So that has creates additional considerations, for any development or any project crossing through this territory, whether it's within a reservation or outside of it. Slide. And here we're zoomed in a little bit more to far northern Wisconsin, the Bayfield Peninsula there, and Schwamingen Bay, showing in that sort of orange color the Bad River Reservation, which the current route of Line 5 passes through. And I'll point out as well that when the line was originally built in 1953, federal Indian policy was quite different then, and tribes didn't have the same level of direct authority and approval over projects or uses of their land. So the pipeline was originally approved by the Bureau of Indian Affairs, where it crossed through the reservation back in 53. And slide. And then this, zooming back out to the full Line 5 route, is a map put together by as part of a study by the National Wildlife Federation, just charting the various spills and releases that have occurred along the line over the course of its life. And they found at least 29 spills that have occurred, which have released a total of at least 1 million gallons of oil along the line. So unfortunately, the line already has spilled and released oil into the environment, and thus there's concern that will happen again somewhere along the line, and continues to pose a risk. So I'll mention, kind of bringing us up towards the present, that along the line where it runs through the Bad River Reservation, several of the easements that allow the pipeline to operate there expired in 2013. And after several years of negotiations between the Bad River Band and Enbridge, they were not able to reach agreement on either renewing those or removing the pipeline or some other compromise. So eventually in 2019, the band filed a lawsuit against Enbridge to remove the pipeline, to shut down the pipeline and remove it from within the reservation. And Enbridge has been opposing that lawsuit for the last 2 years, but simultaneously proposed to reroute that section of the pipeline that goes through the reservation to basically track around the perimeter of that. And I'll hand it over to Rob to get more into that reroute and the work we've been doing around that. Yeah,
sorry, I forgot this slide here.
Oh yeah.
But it's certainly been in the news if you want to find more information about Bad River's lawsuit. Oop, next. So here's a better map, or a clearer map of the proposed Line 5 reroute. You can see shaded there in teal, I suppose, the Bad River Reservation, and in orange, the route of the current pipeline, and the proposed rerouted there in navy blue, it looks like, in that dashed line. So, this does represent about 9 miles, I believe, or at least 9 miles through the reservation. So a little bit more than that outside that they will be circumventing to build a new 42-mile line segment. I think it's important, though, that while it will be entirely outside the confines of the Bad River Reservation, it is still surrounding it and well within the watershed and upstream of the reservation. And so some of the risks they're trying to avoid by ejecting that will persist with the creation this new reroute. So, MEA is opposed to any new fossil fuel infrastructure. As I said, it's certainly a time to think about transitioning away from these types of fuel resources, and obviously building a new pipeline that facilitates the continued operation of a pipeline that's already outdated is problematic. And so, for those two big reasons, as I said, opposed to this project. But, beyond that, there are direct and immediate impacts associated with construction of the reroute itself. It crosses a host of, I think, nearly 200 waterways, and it is a linear project, right, obviously. And so it's a diverse landscape and not just a single site associated with necessarily known impacts across that. It just makes it difficult and complex. And ultimately, as Rob Lundberg indicated, this line has spilled already 1 million gallons to date. And so for us, another spill is not necessarily a matter of if, but when and how much, right? And of course, where, right, in relation to any sort of sensitive resources. So, well, there you have it. Did it again with the slide. but those are the three major reasons. So I want to talk about the regulatory processes real quick, but in the context of our work with respect to Line 5. First and foremost, I think we need to recognize that no state or federal agency actually has direct authority over the route of pipelines in Wisconsin or the authority to issue an overall approval for a proposed pipeline. There's much more authority over natural gas pipelines exercised by FERC, and even by the PSC has more authority there. But when it comes to oil pipelines, that authority does not exist. But there is some authority to regulate certain aspects of the pipeline. So related to the route of the pipeline, the PSC does have the power to grant Enbridge the authority of eminent domain to condemn property along a proposed pipeline route if they can't otherwise reach a voluntary or negotiate with the landowners along the route. Enbridge did apply to receive this condemnation authority from the PSC, and we actually moved to intervene in that case on behalf of 5 different environmental and tribal related organizations, although Enbridge ultimately withdrew its application. The standard there is a very broad one, and it is whether or not condemning the property for whatever project that may be, and in this instance, a pipeline project, is in the public interest. And there's a lot of wiggle room there. And so we did feel like it was an opportunity to push back a little bit. However, Enbridge apparently was able to successfully complete negotiations with those landowners and withdrew its application. Other major regulatory authority at the state level is the Department of Natural Resources, and pointing out here particularly its authority over wetland and waterway impacts. As I said, this is going to cross almost 200 different waterways that are subject to DNR's jurisdiction, as well as impact a significant amount of wetlands along the route. It may not result in the permanent destruction of very many wetlands, but will certainly change a great deal of wetlands and otherwise impact those during construction. So, but this is really the bulk of the remaining authority over this project is in these two water resource permits. Enbridge applied for these on my birthday last year, February 11th of 2020. And DNR sought some more information. I think 2 rounds of more information. There was a public hearing and comment period last June and July. And right now we're in a holding pattern because they can't make a decision on those permits until they complete the environmental impact statement, which I have next here. And so DNR committed to preparing a full environmental impact statement for this process, and that has been ongoing. Although we have recently heard that a draft may be expected late this summer in August or in early September. And just flagging right here for everybody involved, whatever your stance may be regarding this project, you have an opportunity to submit comments to DNR, right? And voice those opinions or even provide technical comments on certain aspects of their draft environmental impact statement, right? And letting them know how it can be improved. And of course, that statement will in part inform their subsequent decision making on things like the wetland and waterway permits. Of course, there are other regulatory approvals involved. DNR has some authority over stormwater permitting and like hydrostatic testing permits, some other general permits, far in the weeds. Other regulatory approvals, ones that we've been watching, involve wetland permitting at the federal level. Not as many wetlands qualify here, but U.S. Army Corps of Engineers has jurisdiction over that. Also, under the Federal Coastal Zone Management Act, our Department of Administration has a role in coastal zone management, which is in the coastal zone, if you don't know, under the CZMA is basically anywhere in a county that borders a coast, and our Great Lakes coast qualify. I do want to flag here, and we will make this slideshow available later on, but I have a link here if you want to find out more about these regulatory processes. We have worked with Wisconsin's Green Fire to develop a series of fairly comprehensive guide going through the different regulatory processes. And just so for the sake of time, I encourage you to take a look at those. So wanted to talk quickly about the felony trespass bill that was passed a couple of years ago. Now, that was 2019 Wisconsin Act 33. This bill is relevant or may be relevant very soon if and when Enbridge were to start construction on a proposed reroute, and say folks tried to show up and protest or to exercise their First Amendment rights in opposition to that. If they were to, say, cross a certain boundary, which may be an imaginary line in some respects, it's not always visible, right? Like in any of those, right? They've heightened the penalty for doing so, right, into a Class H felony. This can also have implications, though, after the pipeline is built, because you'll see under the definition below that it talks about owned, leased, or operated by an energy provider property. So, brief overview, but I'll just back up real quickly. As I said, it can result in a Class H felony if you intentionally enter onto energy provider property without both lawful authority and consent from the energy provider. That's what it says. An energy provider property, as I said, is defined. It includes oil pipelines, an oil distribution system that is operated by an energy provider. So they don't even have to lease or own the property, for example. We question how this worked with like sidewalks and other things, but anyway, we do think that that language is particularly problematic in the context of public trust rights and even treaty, the exercise of, say, off-reservation treaty rights. So think about a navigable water, right? That is held in trust for the public, right? Obviously, a person would have lawful authority to be there under that, but if they're over a piece of property under which a pipeline passes or crosses, right, they are on energy provider property. And so it gets into the intentionality of it. If you look into the mens rea requirements there, it says know or should know. And of course, a lot of times when these cross properties can be posted. And so we think there could be some application of this in the future. Will be interesting to see if there will. There hasn't been. That we know of, but we do think it's an important question, and with DNR effectively holding the power, the public trust power, at least for now, we think we deserve an answer for them, at least on that. And so we have posed the question and look forward to that answer. So Rob, I'll turn it back over to you.
Thanks, Rob. Yeah, I wanted to mention one other really important issue that kind of bridges our work on pipelines and more criminal law issues, and that is the issue of missing and murdered Indigenous relatives, also called missing and murdered Indigenous women, girls, and Two-Spirit people. So as you can see from these two news stories, in recent years, there's been a fair amount of coverage discussing the connection between pipelines, other extractive industries, and increases in sexual violence, disappearance, and murders of Indigenous people. I want to just read actually a quick section from a recent article from the Virginia Sexual and Domestic Violence Action Alliance, because I think it summarizes some of these connections well. And they say that the connection between resource extraction and sexual violence are more direct than you might think. As pipeline routes are constructed, typically cutting through rural areas, which often include or border on tribal lands and the home places of other marginalized people, quote unquote man camps or temporary settlements of workers spring up along the route, with a rush of well-paid outsiders streaming into the surrounding communities. Inhabitants of the camps arrive with no ties to the place or its people. Water protectors from Unitsoten in Western Canada describe the camp culture as one that exacerbates, quote, isolation, drug and alcohol abuse, violence, misogyny, hypermasculinity, and racism among the men living there, unquote. And perhaps unsurprisingly, numerous studies and witness reports connect these camps with increased rates of sexual violence, harassment, and trafficking. And actually just this February, pipeline workers associated with Line 3 construction were arrested for sex trafficking in Minnesota. And Also, multiple man camps have been documented along the stretch of road in Canada, with many cases of missing and murdered Indigenous women, which has been dubbed the Highway of Tears. Slide. So obviously this is a really terrible connection between these issues, which is being more recognized in recent years, and both tribes, states, and the federal government have all been moving to take more action on this. Just within the last year, both the state DOJ under AG Call started a task force on this issue, and also last year the federal DOJ started a task force on this issue to try and find ways to ameliorate it. Slide. And so related to this, and actually related to both the felony trespass bill and missing and murdered Indigenous relatives, it's important to just for a second discuss some jurisdictional issues, and in particular Public Law 280, which is a federal law from the 1950s. And that law basically was the federal government transferring its criminal and civil laws and jurisdiction to certain states, including Wisconsin, within Indian country, which is the federal legal term for tribal reservations and other trust lands that the federal government holds for the benefit of tribes or tribal citizens. So it's important to note that this doesn't include regulatory jurisdiction, so tribes still retain that at least over their own members and citizens. But this law has led to even more complications and confusions around jurisdiction, which often present in terms of which law enforcement has authority to arrest people, to investigate crimes, to charge and prosecute crimes, which courts have jurisdiction to hear crimes or civil complaints. And in Wisconsin, this makes state law applicable within all the reservations and trust lands in the state, except for the Menominee Reservation. So that means that the felony trespass bill is equally applicable within the Bad River Reservation as it is outside of it. And similarly, if a tribal member is assaulted or kidnapped or something like that, similarly, the state has jurisdiction rather than the federal government. And while this in some ways might seem clearer, it has resulted in fact in much more confusion and just a lot more crimes not being solved or handled as expeditiously within or surrounding tribal communities. So I will now hand it back to Rob to just touch on a couple other issues that were requested.
Yeah, it looks like we'll have a time for good discussion after this. Once we get done, we certainly teed up a lot of issues, and we're going to tee up two more. So yeah, we were asked to briefly discuss both of these. I'll talk about WMC v. DNR. So last week, MEA on behalf of 4 organizations and an individual filed a motion to intervene in this case in which Wisconsin Manufacturers and Commerce is suing the Department of Natural Resources specifically for its regulation of PFAS under the spills law. But really, if you read the complaint, realize that it has implications for the spills law in general and could really effectively result in repealing it and requiring DNR to have to reenact it through the rulemaking process on a pollutant by pollutant basis even. And for those who aren't familiar, the rulemaking process right now is very arduous and hard to complete, and there's no guarantee of success there. So we really do see the spills law itself as being at stake and being important. So for those who don't know what the spills law is, it's sort of like, but not exactly like CERCLA or the Superfund law, its federal counterpart. It gives DNR the authority to require responsible parties to clean up or remediate, to the extent practicable, any spill of a substance that poses a hazardous to public health or the environment. And as designed, that's a very broad authority. It gives DNR the discretion to determine when those circumstances come about. Well, WMC is asking a court to say that DNR must promulgate a rule listing every substance at the concentration at which it becomes hazardous, in what volume, in what combination with other substances, perhaps even what resource is at issue, right? And you can see how this would deprive DNR of the flexibility that it needs to respond to a situation that may be an emergency and can be in certain circumstances. And just as an example, WMC tries to point to the absurdity of the spills law, or at least DNR's application of it, by saying that, well, they point out milk could be a hazardous substance, right? And sure, that maybe seems counterintuitive on first glance, right? If you drop a gallon of milk out in the parking lot of a grocery store, right? That's not a hazardous substance spill. That's not what we're talking about. But last year, when we had tanker trucks pulling up next to creeks and just unloading all of the milk that they have in there into a creek, right? That's a different story. And so anyway, it's a problem. And so we intervened. Rob?
Yeah. So I'll just touch briefly on new regulations for the National Environmental Policy Act, which were finalized last year under the previous federal administration. And for those who maybe aren't familiar with NEPA, it is the cornerstone procedural federal environmental law. And its basic goal is to ensure that the impacts of the environment are fully evaluated for any major federal action. So permitting or funding or anywhere where the federal government is involved in a project. It doesn't dictate whether or not a project can happen, but merely is trying to make sure that the government takes what's often described as a hard look at the environmental consequences of a project. So these new regulations limited the scope of analysis of developing an environmental assessment or environmental impact in some crucial ways, such as removing a requirement to consider cumulative impacts of that project as well as others that are happening simultaneously or have happened in the past. And this cumulative impacts is particularly important for a lot of environmental justice issues, because you often there run into issues of siting of multiple polluting facilities, say, or underfunding of certain areas or lack of resources in certain areas coming together to create greater detriment or harm to particular communities. But I won't dive too much deeper into the substance of those rules, because so far I'm aware of already 5 legal challenges across the country filed against those regulations, trying to invalidate them. And this year, with the new federal administration coming into power, they've included these NEPA regulations on a list of agency actions for review and potential rescission and writing new rules to replace them. So it's unclear how long this version of the NEPA regulations might remain in place. But it's also particularly important in Wisconsin. We have our own state law equivalent here, the Wisconsin Environmental Policy Act, or WEPA, and that's what the DNR is currently acting under to develop an environmental impact statement for Line 5, as Rob mentioned. And we do anticipate a public comment period on the draft version of that, hopefully in the next several months here, and would encourage you to check that out if you're interested in commenting. And also our state law, WEPA, incorporates those federal Council of Environmental Quality regulations into the state law. So what happens with those federal regulations is even more important also for projects permitted by Wisconsin state agencies. So with that, I think we're ready to turn to Q&A. I'm excited to hear your questions and have a robust discussion.
All right, again, if you have a question, please use the hand raising feature in Zoom, or else just type in the chat that you have a question. And in the meantime, I know Gretchen has a couple questions to start off with. So go ahead, Gretchen.
Thank you. I'm going to ask an unfair one first. And that's whether you've had a chance to look at this morning's Supreme Court decision on property taking and the Union case in California. And if so, how that will affect your work.
Well,
I have not.
Yeah, well, I'll give you an easy answer. No, I haven't had the opportunity to review that yet, but I look forward to doing so. And if that's something you want to connect on later, I'd be happy to do so.
I would love to. I will. Then I
Okay.
get a freebie. I get a freebie question.
Yeah.
Do you think the abandonment of the Keystone project will increase the pressure for approval of line 5?
I think it might. I think that we have to consider the broader kind of dynamics of that regional system and how it all works together, right? So it certainly could have an impact there. I think one of the things we have to think about, though, are supply and demand, right? And we've seen the demand kind of go down significantly, especially through the pandemic and things like that. And so I think the future is a little bit uncertain when it comes to that, but that could certainly have an impact once, if and when, say, demand were to increase and supply were to increase accordingly. I think Enbridge would have the opportunity to try to put more oil through Wisconsin, especially with line 3 being able to increase their capacity over to Superior if they needed to. And then obviously any infrastructure in the Straits of Mackinac is highly valuable. And so I do expect, right, if they're not fighting that approval over there, right, that just gives them more resources to look elsewhere. So yeah, it's all related. It's hard to speak to it specifically, though, until it happens. But we are certainly thinking about line 5 within that larger context, though, and that informs that relationship.
I think it's worth noting as well that Keystone is a bit different in terms of its permitting and regulation, because it was subject to actually a presidential permit for its border crossing between the US and Canada. And so Biden had more direct authority over that, whereas, say line 3 or line 5 on the federal level are permitted by the Corps. So there's just, a bit of a different administrative structure there of who exactly is reviewing and approving a project, which changes the considerations.
Well, it does cross over there in Michigan, right? But when we're talking about the reroute, of course, that doesn't implicate that.
Yep.
Thank you.
Dennis, do you want to ask your question directly? You can unmute.
Thank you. Any news on the Biden administration's efforts, if any, so far towards redoing or rolling back the Trump administration's changes to the NEPA rules and regs?
I'm not aware beyond what I flagged that, they included it in the list for reconsideration. I haven't seen any notices that they are rescinding that or reconsidering it. But I haven't been watching it so closely in the last couple of months. But I will say that several of the other similar kind of big ticket environmental regulations that were changed in the Trump administration pretty recently have been re-noticed. Basically EPA saying that they're going to reconsider like the Waters of the United States rule or the Clean Water Act Section 401 rule, which has to do with state and tribal certification of different projects that need federal permits. So, if those are any indication, I would imagine that a similar notice of reconsideration or something like that could be coming soon for NEPA.
I think that's right, Rob. And if you're reading the tea leaves on that, it just seems to me that that's just a prioritization of what they'd announced previously.
Thanks.
All right, Peter Goldberg, you have a question?
Yeah, I actually have two, and they're pretty quick. Line 5 carries what? Does it carry dilbit?
It's what I know that it carries is just light crude oil and natural gas liquids. I don't know the exact technical term, though.
Well, dilbit is that diluted bitumen coming out of Calgary that's so irritating, or it wears down the line so much faster and is harder to clean up. I believe that was what spilled in Michigan. at one point.
Oh, down in Kalamazoo.
Yeah.
Well, it certainly, I would assume that we don't know at any one time what's actually going through the pipeline, right? They don't say, but I would assume it could very well include that. Obviously, the oil that goes through Line 5 originates from Western Canada. So I would think it would be safe to assume so, but can't say for sure.
And then one other question. What's happened with the proposed enlargement of the line that was held up for a while in Dane County that runs through almost all the watersheds of Wisconsin? I don't know what number it is.
Yeah, I think you're talking about, was that the Line 61 corridor? It's actually 4 separate.
I don't know.
Going through, if I have to do Wisconsin, right? It goes diagonally, or it's the other way, diagonally down.
Mhm.
It's backwards. Sorry, I can't do it. Across the state, right, and goes through the northeast corner of Dane County. But that also starts up in Superior at the same place. So where Line 5 heads east, those head southeast towards Chicago, and it's actually 4 lines. One of which actually goes from south to north and carries diluent to actually inject in there and help move along some of that heavier petroleum products through those pipelines. So there was a question about whether or not that would be expanded. Of course, that was somewhat uncertain based on what would happen with Line 3. And then now the market has changed significantly, and we don't know what will happen in the future. So some of those same considerations about supply and demand and where they need to get it to go may inform whether or not they pursue something like that. But so far we were expecting that to happen, but then the Line 5 reroute proposal happened and our attention's been diverted and haven't taken any other action. So
Okay, thank you.
you're welcome.
Peter McAvoy, you can unmute and ask your question.
Unmute. All right. I have a question. I guess it's really a clarification that you guys raised about the WMC suit on PFAS, and are they raising the fact that the state needs to go through formal rulemaking on any PFAS regulation? So I wasn't clear when you were making that point in your presentation.
So they not only allege that regarding PFAS, that in order to regulate it under the spills law, they need to adopt a standard right through the rulemaking process. And so any imposition of a standard right now is outside of their authority, right? It's the Act 21 argument, referring to section 227.10.2M of the statutes, right? And so, but they not only raised that with PFAS, they've also said that DNR must promulgate a rule listing all hazardous substances. There's an additional claim in there. And so much greater impact than that. And while some standards may be incorporated by reference, like say, for example, the NR 700 series references groundwater standards and things like that, it's certainly not comprehensive, right? And NR 720 just sets out the process by which DNR or the regulated entity responsible party can determine what their cleanup level is there, but hasn't actually codified the resulting number into regulations. They have a guidance document. So
this would apply. I mean, their proposed action would apply even to emergency situations, emergency spills?
I mean, I think it potentially could, right? They have a lot, depending on how far a court would want to erode their authority and speak to it specifically. I think DNR in responding to, or at least I hope DNR in responding to an emergency situation, be like, nope, our hands are tied, right? If it truly were an emergency, they may try to do everything possible that they can and let a court sort it out later. I could see that happening. But say they did that and someone sued and then a court said, well, no, that's not acceptable either, right? Maybe that's a slippery slope type argument, and I'd be very disappointed if it went that far. But they still have authority in other places to respond to like a true immediate emergency. Whereas here we're talking about their authority to even require the cleanup of substances that, while may not, be spewing a hazardous substance directly into onto people, right, is nevertheless seeping into natural resources and needs to be addressed relatively quickly.
Yeah. Okay. Thank you. But your intervention is still pending, right?
Yep.
Your request.
It is.
Yeah. Yeah. Thank you.
Bobby, do you want to unmute and state your comment?
I didn't really need to, but I will. Rob and Rob have heard this before. I'm concerned that we don't know what's flowing across Wisconsin in Line 5, because although Enbridge says that it's lightly refined crude, the refinery in Superior has been shut down for 3 years. So whatever's coming through that pipe isn't being refined in Superior. We have no idea what's in the pipe, and they have nothing telling them that they need to disclose that information.
Thanks, Bobby.
Janice, do you want to unmute and ask your question?
Another question.
Dennis, I said Janice.
Okay.
You're next, Dennis.
It happened in my family all the time. Janice, Dennis, it's just one of those things. Sorry. I have a question. Does the Department of Health have any authority over PFAS or other chemical spills?
That's a real good question. So our groundwater law in Chapter 160 does give the Department of Health Services a role in developing groundwater enforcement standards, which are based on it's like a public health drinking water standard, and of some of our most vulnerable. So it's the lifelong impact to a toddler or child that weighs roughly 22 pounds at a certain concentration over the lifetime, right? So that's what a goal that they set that at. If there aren't any other federal numbers or things like that require them that they're required to choose. So, but when they don't have guidance from the federal government or anything like that, for example, when it comes to PFAS, right, they are able to conduct epidemiological reviews of the available scientific information out there and then recommend enforcement standards to the Department of Natural Resources. So that's not any direct regulatory authority, but what happens there is DNR is required to introduce a rule proposing to adopt those enforcement standards. And so that's what they've done in, I believe 2 cycles now. I don't know if they've got the second groundwater rule issued already, but they do these in cycles. So cycle 10 included 2 PFAS compounds, the ones that have been most well studied, PFOA and PFOS. And then cycle 11 of DHS's review included, I think approximately 20 more. This is a family of thousands of highly toxic human-made chemicals, but the original list that DNR asked for was something like 34, 35 particular PFAS for them to review, and they just don't have information about half of them to review, and simply had to say we can't recommend anything. There is no info out there. So just recognizing that we're still learning a lot about many of these, but we do know a great deal, particularly about those 2 main ones, but are learning more almost every day about the others as well. Over other chemical spill, I can't think of anything directly off the top of my head, but they do have a really important role, which should be beefed up, when it comes to things like lead contamination in children and things like that. So that's what I have on that.
Dennis, go ahead.
Rob, I'm wondering whether WMC's arguments and the thrust of them may be broadly applicable across most or all of DNR's regulatory areas, not limited to the spill law. I think they're looking to do something far, far more insidious than gutting the spill law.
So we can even take a step further back from just this case, like the WMC v DNR case specifically, and look at the way they're bringing the challenges, which is predominantly based on a theory from 2011 Wisconsin Act 21, which says no agency may implement or enforce a standard unless it's explicitly authorized by statute or rule. That's a paraphrase, but that's mostly it. And so they've used this as a defense in other cases that we've recently just, MEA has, our colleague Andrea Gillette argued in part before the Wisconsin Supreme Court back in April. We may get a decision any day now. That case, right, will likely impact this one, right? And this could very well impact the next one. And so whatever broad principles can be distilled from those will certainly apply. However, whether or not an agency has that explicit authority does depend on the specific statute, right? In a reading of that. And, I could say the court coming out either way, depending on the specific statute, despite those, the broader principles that could be distilled. So, yeah, it absolutely can have a broader impact, but we're actually waiting on a pending decision right now that could have that very impact you're talking about. And that, just so everybody knows, those are a Kennard Farms case and a Clean Wisconsin case.
Just want folks to know what our corporate overlords are up to.
And I think we see similar arguments also raised in the rulemaking context as well, trying to ensure that every section of any new rules that are proposed for promulgation similarly don't exceed whatever is argued to be the explicit statutory authority.
I have a question about the Straits of Mackinac. So Enbridge is, trying to go around the reservation in Wisconsin, but what happens if they can't go across the Straits of Mackinac? What's their option for Line 5 in that case?
Well, they could terminate it right there before that and truck it over and then put it back in. That would be one very infeasible solution, but it would be very expensive. That's probably not going to happen. They could explore other routes like by rail or shipping. That's what they'll say. Like, well, if we can't pipe it, we're going to have to ship it, and that's more dangerous. Right? That gets me back to the need for the pipeline or the oil in the first place. But anyway. But upstream of that, right, there is an offloading facility just over the state line. I believe it's River Rapid or Rapid River, Michigan, that does offload some natural gas liquids for propane use in the UP and things like that. So it could still serve a limited purpose for that, but that wouldn't get anywhere near their capacity right now and may not make economical sense for them to continue. So, yeah, if they can't get it through the straits there, it certainly calls into question the existing need to operate it here in northern Wisconsin, even for that limited purpose. And we're hoping that DNR's draft environmental impact statement will analyze available opportunities for homeowners and other folks up there to, access what they need to stay warm and keep the lights on.
Gretchen, you had another question? Gretchen, did you have another question?
Just wonder if you want to say anything about the bill that would provide grants for the PFAS, but also provide them with immunity from civil liability.
Yeah, it's two-sided, right? I mean, in the first instance, really great that anybody in the legislature is considering putting money towards solving any problems related to PFAS. We need the legislature to act here, right? The DNR can only do so much. But when it comes with strings attached like this, I question the motive for the bill, and right, I think just on its face, right, there are problems with it, and certainly not being able to hold responsible parties accountable, right, it is a big problem because of the potential to shift that over to taxpayers. So yeah, good in the first instance. We need money to put towards this, although $10 million isn't going to get it likely, but it can't come with the strings attached like this, right? There's just too much uncertainty. We don't even know all the places these things are coming from, and don't know who or what we're absolving of liability potentially by just accepting a grant and trying to help out, your community.
Thanks.
We'll do one last question, and Sheila, it's yours. So go ahead and unmute and ask the question.
Hi, this is a general over question. Is there any precedent in the United States of shutting down a functioning oil pipeline?
Well, I'll limit it to interstate oil pipelines, right? I certainly think, some regulatory authorities like in California and Oregon and maybe even over in Maine and elsewhere have been successful in shutting down smaller intrastate pipelines, right, that don't cross the borders. But I can't think of anything off the top of my head that would be the United States government requiring a functioning oil pipeline to stop, right, pumping. I can't think of one. I can think of all sorts of instances, right, where opposition to a proposed pipeline, right, has resulted in that not going forward whatsoever. I guess I would ask others if they can think of any. Maybe it'll jog my memory, but I certainly can't.
It sounds like no one has any thoughts on that. So Dennis is shaking his head.
I'll leave you with this. Let's be the first.
Thanks. Yeah, I was thinking of precedent and their concern of doing a precedent they are not interested in. So,
well, I mean, I guess I'll elaborate on one thing, right? And that does loom large, right? When we said with the reroute is not directly implicated, like Biden's approval over international pipeline, but there is still some federal authority over the pipeline, just residually through treaty power and things like that. And it'll be interesting to see how Enbridge tries to use it. They've already tried to use it a little bit, right? And right, it may not be how the United States can shut one down, but how it's accidentally backed itself into an agreement it now can't get out of. So,
and along the same line, Rob, do you know if they've attempted to figure out a way to dismantle some of the infrastructure? I mean, in general, it's going to have a targeted way of addressing how to do things in a systematic fashion. Has there been any thought about that? Or
so you're talking about as we're transitioning away from fossil fuel infrastructure, what to do with what's left there, right? Not functioning anymore?
Yeah, I mean, they're going to have to do a targeted drawdown. Who are going to be the winners to have it drawn down first,
Oh, yeah. Okay. I sort of see what you're saying. I think that kind of just, again, goes back to the market question and how that develops and what's available. And if we shut off, we're successful in shutting off line 5, does a fight then turn to the line 61 corridor? So I think that's all informed by subsequent developments I can't predict right now. But is certainly a question, right? We talked about it earlier. By shutting down Keystone, does that put Wisconsin and others, Minnesota and Michigan at greater risk of more oil going through in the future? Perhaps so. So that could be like a loser type scenario. But I think, again, that remains to be seen. The other thing, though, is just about like abandonment, right? Sometimes ripping some of this infrastructure out, right, can cause just as much damage as putting it in. And which can cause a problem. But also these pipelines can get air and float to the surface and do all sorts of weird things on the environment. And we also have to think about how much it would cost to take them out and what that might do to the operator's profit margins as well. So but again, abandonment hasn't been so much of an issue, right? Because getting them shut down in the first place has been a battle, but that's right where we are.
Thank you.
With that, I want to thank Rob and Robert for their presentation today. I found it very, very interesting. It's an area that I'm not familiar with, and I think it's a new area for WJI to talk about. And I think we really, really appreciate the work you put into your presentation. We've hit a little bit after 1, so we'll wrap it up. And I want to thank all of you for joining us for this past hour. Look for our next salon in July. The topic and speaker is still being arranged, so we'll get the word out about that. Probably a Wednesday in mid to late July, so look for that. Also, please save the date of September 9th for our return to an in-person speaker event. And we're having Mark Joseph Stern, who's a U.S. Supreme Court commentator, join us at that. We hope you stay safe until we see you again.